Briefing a case is a valuable skill that will help you understand what happened in a court's decision. It's especially useful for students in law school. Although it may seem difficult at first, there's no real magic to it. It's just like any other skill that takes some practice to master. So let's dive right in. First, it's important to consider why you're briefing a case. Generally, law students brief a case for three main reasons. 1. It helps you understand and analyze what a court's opinion is about. 2. It helps you remember the case when you discuss it in class. And 3. It helps you review the case when you're studying later or preparing for an exam. Those goals tell us a few things about what a case brief needs to include. Your case brief needs to have the important information from the case, so that you can rely on the case brief when studying or participating in class discussions. The case brief also needs to be concise and well organized, so that you can quickly review it for class discussions. You should also write your own case briefs, instead of just relying on a brief that you find online or from another student, because the act of writing out your own brief will help you process and understand the court's decision. In fact, the process of writing your own brief is arguably the most valuable part of case briefing. With those goals and requirements in mind, let's talk about what usually goes into brief. In terms of format, if you're just using the case brief for your own work, there's not really one specific way that's best to brief a case. As long as the format you choose works for you and meets the goals and needs that we just outlined, go with whatever format you like. Written documents, flowcharts, sketches, they're all fine. Of course, if you're writing a case brief for a particular professor or as an assignment, he or she might have specific requirements for the brief. Make sure you follow those. Okay, let's look at the standard version of a case brief. The 8 usual sections of a case brief are the caption and court info, facts, procedural history, issues, holdings, rationale, disposition, and other opinions. The caption and court info section should include who the parties were to the lawsuit, what court the decision your briefing came from, and the date of the opinion. Make sure that this section of your case brief also tells you where you can find the case. For example, if the case is in your textbook, note in your brief on which page the case starts. Next, the facts section should include a brief summary of what happened. Often, your summary will be about something that happened prior to court. For example, maybe someone entered into a contract that didn't work out, was negligent in a medical procedure, or fell down a hole until their dog told someone where they were. Sometimes, you'll want to include facts about what happened before anyone sued, and facts about what happened after the lawsuit started. For example, maybe Jack saw Jill commit a crime, but when the prosecutor called Jack to testify at trial, the judge excluded Jack's testimony under some evidence rule. In that situation, if the court talked about the exclusion of evidence and was ruling on the evidence issue, you'd probably want to include that information too. So you're probably asking yourself, how do I know what facts to include? If you are asking that, first of all, stop talking to your computer. It can't answer you, and people around you are looking at you like you're crazy. Knowing what facts to include is difficult. You want to include enough facts that you understand what caused the issue. You also want to include any facts that were important to the court in deciding the case. One way to figure out what facts to include is to ask yourself, what facts did the court talk about when applying the law to the case? Or ask yourself what facts the dissent or concurring opinions relied upon. Or ask yourself what facts, if they were changed, would make the case's result change. Just don't ask yourself those questions out loud. People will think you're crazy. As a final note, in this section, sometimes you might need to include a lot of facts so that when you come back to study using your case brief, you'll have all the information about the case. That's okay, but if you have a long facts section, you might want to include a shorter summary of the key facts so that if you're called on in class, you can look at that summary quickly and be ready to respond to the professor's questions. Next up is the procedural history. This section explains how the case got where it is now in the legal system. You should explain things like what causes of action the plaintiff brought, or what the defendant was charged with in a criminal trial. You should also include who won in the trial court and why, what happened on appeal and why, and what happened in any other court proceeding and, you guessed it, why. After the procedural history section, most case briefs move on to an issues section. Here, you want to state the legal issues in the case. For example, the case might be about something general, like whether a police officer needs a warrant to look in the trunk of a car. Or it might be about a more specific question, like whether a police officer needs a warrant to look in the trunk of a car when that officer thinks that someone is trapped in that trunk. To help identify what the court specifically decided, look at how the judges or justices described the issue when ruling on the case. Look at what facts the court relied on in its ruling. Look at what the dissent or concurrence talked about. Identifying the legal issues is tricky, but you'll get better at issue spotting with practice. A good indication of whether you're successfully identifying the issues in the cases you brief is what happens in class. Listen to what the professor asks other students about in class when discussing those cases. If the professor mainly asks about things that are related to the issues you spotted in your case brief, that's a good sign. When in doubt, talk to the professor before or after class, or, if allowed to do so at your school and on your assignment, talk to other students about what issues they spotted and why. Next is the holding section. This is where you state how the court answered the issues that you identified. So if the issue was, does a police officer need a warrant to look in the trunk of a car when they hear someone is stuck inside the trunk of the car, the answer would be either yes, the officer does, or no, the officer does not. Some students like to leave the holding section at that. Other students like to say a little bit more, like, no, the officer does not need a warrant in that situation because the person stuck in the trunk was running out of air in an emergency situation. Either way, you'll want to include more explanation in your rationale section. This is where you describe why the court answered the issue the way that it did. Your issue section, holding section, and rationale sections should feel like 3 chapters to the same story. Your issue section tells the reader what the story is about. Your holding section tells the reader how the story turned out. And your rationale section tells the reader why the story came out that way. Another section that many students often include is a disposition section. This part of the case brief is kind of like the procedural history for the end of the case. It says what the court did procedurally in this case. Did the court rule for the appellant or the appellee? Did the court award the defendant money damages or issue an injunction? Did it agree with the trial court and affirm? Or did it disagree and vacate the trial court's opinion? Maybe it remanded or certified a question to some other court. Generally, the disposition section will be very short. Finally, you should include a section that notes whether there were any concurring opinions, dissenting opinions, or other types of opinions. If a casebook includes a concurring or dissenting opinion, or if a professor has had you read a concurring or dissenting opinion for some assignment, there's often a reason. So you should note that the concurring or dissenting opinion was in the case, and you should summarize that opinion briefly in your case brief. And that's briefing a case. There are many ways to brief a case, and the way that this video described is far from the only one. For example, although this video didn't describe it, some case brief guides recommend including an analysis section at the end of your case brief where you write down what you think of the case and how it came out, or how the case you briefed fits together with other cases that you read for class. You can include that kind of section if you find it useful. Although briefing cases may seem difficult and may feel like extra work on top of your already busy law school schedule, briefing a case is kind of like investing in a retirement account. It'll help you down the road, and you'll probably feel better knowing that you did it. But a case brief also has immediate benefits. It also helps you understand the case better, and it will help you prepare for and participate in class. I hope this video helped you. To learn more about briefing cases, and for other opinions on how to do so, try the links in this video's description.